All right.
Okay. Sorry.
I'll repeat it just so the recording gets it. I broke it down into 4 issues, and the first issue is whether you agree that should Park have had the duty to mitigate the damages in this case, and to raise your hand if you believe that they should have. Park, that is, should have mitigated these damages using the raise your hand feature. No one. Tiffany. Anyone else? All right, Tiffany, you want to explain why?
The record, I mean, I'm not saying my belief is right. I just believe that out of contractual fairness and the principles of contract law, that there should be a duty to mitigate your damages, but the record does support a finding that the damages shouldn't have been mitigated, and there were cases that were presented, case law that was presented that supported that finding. But as a, I don't know, as a basic principle of contract fairness, I think that, the landlord did have a duty in this case to mitigate the damages. And I think there are issues here that show that they tried to mitigate the damages, but they fell through because I believe they had another buyer lined up, and then that fell through. And then when the appellants tried to release the space or sublet the space, it was like the provision in the contract said you can't sublet, but you could present other people to take the space. But when they tried to do that, they were blocked at every end. So I feel like they gave them an option to mitigate, but then kind of took it back.
Do you think that it has anything to do with the fact that this was commercial as opposed to residential?
What do you mean? I'm sorry.
Like this was a commercial lease as opposed to a residential lease. Do you think there's like a difference in the law that may have applied here? Or you think that no matter what, the landlord has a duty?
I mean, I think out of basic contract principles, we learned in contracts you have a duty to mitigate your damages, and I believe the reasons are for judicial efficiency, things of that nature. Like I don't think that even if it's commercial or residential, I think that there was a duty to mitigate, and I think they tried to afford him that duty because they said, okay, here's the, I think it was clause 8. You can mitigate, you can sublet the space. We're going to, they tried to find somebody, and then they turned around and said, no, you can't, we're going to take it down. They called all the news outlets and were like, no, take it down. So I don't know. I'm just not happy with that.
Okay. Thank you. Kyle?
I agree with Tiffany that generally in contract law there's a duty to mitigate, but when it comes to property, it's different because it's not just bound in contract law, but it's also bound in property law now. So generally in New York, there's a duty to mitigate in residential leaseholds, but generally in commercial leaseholds, there isn't. And from the agreement itself, I don't see a duty to mitigate because all it stated is that they had the ability to offer new tenants, not a sublet, a new tenant, which they failed to do because when they offered someone to them, they were offering it as a sublet, and the sublet carries different rights and obligations than a brand new tenant does. So just because they said you may mitigate your damages by finding us a new tenant, I don't believe they assumed a duty to mitigate because under the law of New York, they don't have a duty. So why would anybody usurp a duty that's not already there? That's not expressly stated in the agreement.
Thank you, Kyle. Does anyone else have an opinion on this? And whose side are you on, Kyle's or Tiffany's, basically? All right, I'm just going to go down the list and ask everyone then. So I'm just going to go in my order. So Alyssa, what do you think?
Yes, I agree with Kyle on this one just because it didn't specifically state that they had to. So I just am more aligned with Kyle's reasoning on this one.
Okay, thank you. Jacqueline?
Hi. I wholeheartedly agree with Kyle. Real estate is completely different than regular contract law. As he stated, property rights as a sublease as opposed to a brand new tenant are two totally different leasing options, contract options, and would give that new person two totally different contracts. And I think it's just reasonable for the tenant to support it.
All right. Thank you, Jacqueline. John?
Yeah, I mean, I agree with Jacqueline and Kyle and Alyssa. There is really no reason for them to act upon that they don't have to. Like Jacqueline was saying, there's a big difference between subletting and having a brand new tenant. And due to the fact that it's commercial, I just don't see why they would have to when it wasn't explicitly stated.
All right. All right, cool. Thank you. Caitlin?
I agree with the rest of the group. I don't think that they had to do it solely because paragraph 8 was a little iffy to me.
All right, cool. Thanks. Catherine, you always have something interesting to say.
I do agree with Tiffany that the contract law does create the ability for parties to go against the common law, that you can't, that there is no duty to mitigate, but I don't think this specific contract created that, expressly created any duty to mitigate.
Okay, thank you. We went through. Well, Melissa?
Hi. I also agree with Kyle. It's commercial property, so therefore there is no duty to mitigate on commercial properties.
Okay. I don't. Hold on. Okay. You, son?
You hear me?
Yes.
Okay. What I'm thinking is,
Deliberation.
okay, this is or about as a matter of law, in terms of residential, not residential, commercial one. So I totally agree with Kyle. No duty to mitigate its damages.
Okay. Thank you. And then Rachel?
Yeah, I think I agree with Kyle just because it's commercial property. I was a little bit torn at first because it seemed just practical that you would want to mitigate, but there's really no duty.
All right. So back to you, Tiffany. Has the group convinced you otherwise?
Not really. I just, especially reading the record, there's a lot of issues regarding, like, factual issues regarding the exit from the property. So I believe a duty to mitigate should be implied or imposed because, for instance, there was an issue regarding the fact that they were trying to get them out. They were trying to get the attorneys leasing the property out, and we don't know what really transpired there. They're saying that they basically were forced out. They made a good faith effort to meet with them and to renew the lease, and that was met with unfairness. They were trying to, move to a different floor. They wanted to move to a different floor. They basically force them out. So if you're going to force them out, then why should they pay for it?
Do you think it has anything to do with the fact that the rent was so low that they were getting like such a good deal? Like Park would have lost money if they would have allowed Kurzman to continue even at a higher rent rate but less than actual value.
No, I understand that, and that's totally, that's commercially reasonable. Like, if you have a property and you want to sell it for a higher price and you have this tenant that's not paying the higher price, that's fine. But it's initially, they did not want to leave. It was the landlord who wanted them to leave, and they took actions to leave. and with supposedly the landlord's permission, and because the landlord wanted them out, it would be beneficial to the landlord to have them out. So now we want them to pay for it also. We want them to pay for being basically kicked out or forced to leave. I believe they were there for almost 20 years, did the record say?
Yeah, it was a long time.
Yeah, it was a really long time. So after being somewhere from 20 years or so, now you want them to leave, and now you want them to pay for it because you were trying to basically do them dirty because you had somebody that you thought was going to pay a lot more, and they bailed out on you. Now you want them to pay, and I don't think that's acceptable. I don't think we should condone that behavior.
Okay. Jacqueline?
In this case, like you were saying, a contract is a contract. The contract was for a certain amount of time, and after that certain amount of time, it ended. Once the contract ended, obviously they entered into new negotiations to renegotiate a new contract. That should have, yes, it does have bearing because they have a working relationship. They've been in this relationship for 13 years, I guess, or whatever it was, from 1997. But the fact that this is a business deal, obviously it's a contract, so they need to make money off of this deal. Obviously, real estate prices, as we've known from 97 to 2012, are going to drastically change. So the fact that the tenants are expecting to get the same price at the same rent or close to, we don't know what the negotiations were, but you can assume that they were trying to get close to what they were paying, is just not feasible. These tenants, the landlord was trying to be reasonable and offered them a different floor and offered them the same address but a different floor, and they didn't want it. They just wanted what they wanted, and that was it. And the contract fell through. That's just how that goes. So to say that they were forced out, they weren't forced out. It's just negotiations fell through.
Thank you, Jacqueline. You, son?
Okay. Based on appellant brief, page 10, my understanding is before the termination of the lease, after informed landlord is gonna increase the lease, a tenant decide to vacate the premises before the termination of the lease.
Yes.
So I think even though landlord wanted to renew the lease at market rates, but because the tenant decided to vacate before the lease termination, so I think landlord has no duty to mitigate its damage.
Yes. Kyle? Thank you, son.
I think that correct me if I'm wrong. I believe the negotiations it's for a new lease. It's not for the current lease that they're in.
Right.
So that would have no bearing on the current contract. Where you're negotiating a brand new contract, you still have your obligations under the original contract. The breach and the mitigation and the damages are arising out of the old contract. So I don't see how any of their actions can have any effect on any of the actions on the new lease can affect the previous obligations under the lease.
I'm under the impression that Kurzman was allowed to stay until December 2012, I think, and they left in September 2011.
Exactly. So they're breaching on their old obligations, nothing new, and all of the negotiations were for the new agreement, not the existing one.
Yeah.
So maybe they would have no bearing on the existing contract.
And they made a good faith effort to negotiate. It's just negotiations fall through.
It's business.
Yeah.
But Tiffany, I have one question for you. Were you finding the duty to mitigate expressly stated in the contract or implied in the contract? Implied. Well, see, my only issue with that is, you can't imply something in a contract when the law is already contrary to what the implication would be. if they really wanted it, it should have been stated. You're not going to imply something in a contract when general practice is that doesn't occur.
Well, another issue I have is these are attorneys, so they know better. They should have put in everything that was stated in writing. So that's another issue I have with the case. I didn't understand why, as attorneys, you would not write down what you said, because I believe not in the. I'll tell you what document. It's in the trial record. The trial record raises serious issues of fact as to what really happened with regard to the lease. I believe they paid past due obligations. What was not paid was the time. I don't remember. There was a period of time that wasn't paid, and they're contesting that, but there were other penalties that were paid. So my issue is the facts in the trial record make me feel like there was a duty to mitigate there, because if they were, I'm saying forced out, but I feel like the landlord wanted them out. It was beneficial for the landlord to have them out. The landlord was trying to double, not, charge them like, slightly above what they were paying. They're trying to double what they're paying. And they've been there for 20 years. I would have said, no too. I'm a loyal customer. I've been here for 20 years. I'm not going to, you want to charge me double, So there was an issue with that. And there's an issue as to whether there was another buyer. And there's an issue as to whether the landlord said, hey, you can do this. You can leave. We have somebody else. Like this, basically, as soon as you leave, you better. I'm pretty sure the trial record reflects that. So that's my issue. I'm finding an implied obligation to mitigate because of the facts in the trial record.
Okay. John's had his hand up. John?
Yeah, I mean, everyone basically summed up what I was going to say. I do agree that, maybe ethically speaking, maybe based on their past relationship, they should mitigate, but because they don't have to, and because once again, this is commercial, this is a business decision, and because they don't technically have to, according to the law, there's really no reason why they should.
All right. Thanks, John. Jacqueline?
Yeah, I'm trying to find it in the exactly what case, but I believe there's case history that specifically states that even if the landlord starts to mitigate damages, like they start assisting you and then stop, they have the right to do so because they don't have a duty to mitigate. So they can do it out of good faith, or they could just, start doing it because it benefits them, because as it states in the record, it doesn't benefit the landlord at all to have an empty space and no rent coming in. And as we stated, the tenant has a duty to pay out until December
2012.
Whatever it is, 2012, regardless of whether a new tenant comes in. So they're going to be getting paid double rent. Why wouldn't the landlord want somebody to move in? It just wouldn't, it doesn't make sense. But as it states, the reason why the landlord stopped it was because the tenants had used the word sublease. And like we stated, a sublease is completely different from a new tenant. So I would believe that the landlord wanted to clear up that before it, before somebody contacted them and tried to sublease. Now now it's gone down a road that it's hard to backtrack out of, I would think.
All right, so it seems like everyone but Tiffany is on the same page here. So Tiffany, would you be okay with agreeing that it is not expressly stated that there was a duty to mitigate, but in a dissent perhaps that it was implied, you would think? Yeah? Okay, thank you. Good dissenter right there. All right, so my second issue then, does anyone else have anything left with this? Are we good? Yusun, your hand's up.
Oh, I'd like to kind of mention about case name.
Oh, you have the case that Jacqueline just
Yeah,
referred to? Okay.
Yeah, Jacqueline, Holy Properties.
Holy, there you go. Okay. Thank you, Yusan. All right, so now the second issue for this case is that I have is whether the stipulation conferred a right on Kurzman to sublease to new tenants. So did that stipulation 8 give them the right to go out and sublease the property? So raise your hand if you think that they did have a right to sublease, to go out and find actual new tenants to put in the property.
I have a question before I answer that question.
Sure.
Are you saying they had a right to sublease before they defaulted on the lease?
After defaulting.
Okay.
Thank you. When the stipulation took place, so that's after they left and then the stipulation.
Okay. No hand raised.
Okay. So anyone think that there was a right to sublease per the stipulation? No? All right, I'm just going to go down the list and make sure. But all right, so Alyssa, you think that there was no duty?
Correct. I don't think there was a duty.
Okay. Jacqueline, you already said you don't. John?
No, I don't believe there was a duty either.
Okay. Caitlin?
I don't believe there was a duty either.
Catherine?
No, I don't believe there was a duty to sublease, only relet.
Okay. Kyle?
No, I don't think there was a duty to allow a sublease only because under the initial contract, subleasing was prohibited, and the stipulation clearly states that they have the ability to find a new tenant, not a sublessee.
Right. Melissa?
Nothing in the stipulation says anything about sublease, so no.
All right. Rachel?
I agree. There was no stipulation for sublease.
Tiffany?
I agree with everyone else, specifically Kyle. The plain language of Provision 8 does not allow for a sublease, so no.
All right. And you, son?
No right to sublease, only allowed a new potential tenant.
Right. Okay. Well, does anyone want to explain just the difference in their mind between subleasing and presenting a new tenant is, just so that in case someone's writing this opinion, we have that clarification? Tiffany?
The sublease, under my belief, would be to take over the previous lease. They would be taking over the previous lease and the obligations under the previous lease. The relet, I believe, would be to just here's this person, it's a good candidate. They do the credit check, they do all this stuff, and they let them in. So it's up to the landlord's decision, whether to let this new tenant take over.
Okay. John? Thank you, Tiffany.
Yeah. Subletting is more so, I guess, like a temporary option, whereas finding a new tenant would allow them to, I guess, maybe renegotiate. They wouldn't have to inherit the terms that the original person had with regards to the sublease.
Thank you, John. And Kyle?
The only major difference I see in the sublease is that absent a third-party beneficiary agreement, a landlord cannot sue the sublessee because they're not in privity of contract. So, and then the original tenant retains a reversionary interest in the lease. So it adds more obligations and creates kind of a mess because now the landlord can't sue the subtenant unless there's an agreement or there's an assignment, and they can only sue the direct tenant, and then the direct tenant would have to sue the subtenant, and it just creates a mess. That's why so many landlords are against it.
Okay. Thank you for the mini property lesson. He was a property RA TA, so he knows his stuff. John, did I not lower your hand, or did you?
Just to add quickly, it's just pretty
Okay.
much just wiping the slate clean. It's just that the owner of the property is really just protecting himself. That's what it comes down to.
All right, thanks. So we're all in agreement here that the plain language does not allow for a sublease. Okay. Anything else on this issue before we move on? All right. My next question is whether did Park breach the contract by not allowing Kurzman to advertise? So they put out that advertisement, and did they breach their basically not the contract? Did they breach the stipulation? Kyle?
I wouldn't say that they weren't allowed to advertise. I would say that they disagreed with the advertisement they made, and that's only because the advertisement stated that it was a sublease and they're not looking for new tenancy.
So it was the language that...
It's just the same thing as the last argument. It's because they used the word sublease. It wasn't that they said, oh, you can't advertise at all. It's that you advertised improperly, and it affected the landlord's rights and rights. So that's really why the landlord didn't say, no, you can't advertise. He said, you can't use this advertisement.
Okay, I agree. Jacqueline?
This is where I had a little bit of an issue. Like Kyle said, that they are stating that the reason why they took out the article is because they used sublease instead of lease, but I might have missed it, but I didn't see anywhere because they told the advertising company that the property wasn't ready yet. They didn't state that it was because the terminology was wrong. And I don't see anything where it states that they contacted the actual tenant to notify them that they utilized the wrong terminology. So that's like the only thing that I'm just a little confused about, like why, like if you were trying to do this clean and not be a bit, I mean, obviously it's business and they're trying to get what they want and they want these guys out, and I get that agenda, but if they were really trying to just, I don't know, it doesn't seem that they made it clear that that was the reason that they pulled it. They seemed to pull it and then tell the company that the property is not ready for anyone to move in. So I would believe that that is like a stop.
Do you think that was a breach?
Yeah, it's a semi-breach because why the other side of it is why couldn't the tenant go elsewhere to advertise? Like just because there's one, I mean, I know they said this is the largest advertising company, which I get, but why couldn't they have gone elsewhere and advertised and tried somewhere else to advertise? They didn't seem to try very hard other than this one article that they placed. So I guess I'm arguing both ways. And
Okay, we'll come back to you. Thanks. Catherine?
Yeah, I kind of agree with Jacqueline. I feel, I don't want to say it was an all-out breach, but I do think it's an issue of fact, a question of fact that should not be just dismissed on summary judgment.
That's my next one. So, but yeah.
So that's really, I guess, my reasoning that
okay.
those should have been taken into consideration, the emails back and forth, and it seems like more of a question of fact.
Kyle, did you have your hand up? Did I lower?
Yeah, I don't have it in front of me, but I think, if I remember correctly, that the agreement stated that they had the right to find a new tenant. It didn't say they had the right to advertise for a new tenant. So if the right's not expressly listed in a contract, especially if these are attorneys and they should explicitly list everything that they intend to do, I don't think we should infer a duty or a breach based on something that's not explicitly stated.
Wouldn't it be reasonable to think that in order to find a new tenant, one would have to advertise? I mean, that's just like, how else is he going to find? I mean, word of mouth, but how else is he going to find a new tenant?
Wouldn't you, if it's that important, shouldn't you list it in a contract?
True.
If you're an attorney?
Yeah, you are right, and it is an attorney. But so that's why I'm. If you're looking at it from a reasonable point of view, That's why I think it shouldn't be dismissed on summary judgment, and I do think it should be argued in court. like I didn't look at all of the facts and like all of the emails that went back and forth. I didn't read everything, so there might be more clarification in there. I don't know.
All right, thank you. Who just had their hand up? Tiffany?
Isn't there an issue as or regarding whether the landlord-tenant relationship was terminated by operation of law, so then they wouldn't be obligated under the previous lease?
Yeah, the terms of the lease were no longer, the lease was over when the stipulation was passed under my interpretation.
So
the advertisement said to sublease, but the stipulation says, notwithstanding anything herein to the contrary, nothing herein shall prohibit respondent from locating and or offering to petitioner a potential tenant. So it doesn't say anything about subleasing, like it just says offering. So I think that's where the argument is whether or not the word sublease in the advertisement is really like, that's what they're harping on basically.
okay, because I thought I heard Kyle mention the old lease, so I wasn't sure if everyone thought that was still in effect or not.
No, the lease isn't in effect once the stipulation is, I guess they agreed after. That's at least my interpretation of it.
Okay, so I agree with your interpretation then.
Kyle?
The only reason I reference the old lease is because the stipulation states that the parties maintain their rights and obligation and remedies under the initial lease. It's right above it in, I think, Clause 8. But I completely forgot what I was going to say.
Okay,
I'll come back to me, Jeff.
Okay. Catherine?
I think maybe what you were thinking of was their first affirmative defense was that it was a termination under the lease. So that they kind of fell back on this wording of the provision and the mitigation of damages as a secondary. They were first going with it. Their obligation was completely terminated and they didn't have to pay based off of that. But then I think they realized that wasn't a winning argument.
Kyle, do you remember yet? Yeah.
Yes, I remember now. The main thing is with the agreement is it states that they have the ability to offer a tenant. It doesn't say the landlord has to accept a tenant. It doesn't say the lessee has to do this. I don't see a breach of contract by stating that, you know, they've had them remove the advertisement or the property's not ready, because we don't know the state of the property after the tenant moved out. It may have been repaired and refurbished, especially that they were tenants for 20 years and this is commercial property. It doesn't say that we have to accept it. They have to act in good faith because it's a contract and there's no other standard, I believe, listed in the agreement. So there's a good possibility there's a valid reason why they said the property wasn't available. And the park would still be liable, or Kurzman would still be liable for their damages under the initial contract.
So I think that Kurzman should have been able to advertise under the stipulation in order to present a new tenant. However, I think that the fact that they used the word sublease in the advertisement implies that the location was ready for move-in and like they were going to be able to like come and accept it and have a place to do their new business. And I think that that's what's misleading. So I think it's the word sublease is the reason why that they should not is why the advertisement should have been taken down, and that's why it's not a breach. Tiffany?
I just had a quick question regarding the language of paragraph 8. So in that language, the landlord is saying you can present other tenants for our consideration. Isn't that an effort to mitigate the damages? Isn't that language expressly allowing the land? I'm still hung up on that. I'm sorry.
It's okay.
I'm just like, I just feel like the language is expressly stating. Now that I reread it, it's like it's saying that we're going to let you present to us other tenants, and if we approve them, then they'll take.
There's nothing in there that says they have to accept the offer.
No, but that's not what I'm saying. I'm saying they don't have to accept it. that they could say no, they reserve that right. But by putting that language in there, did they create a duty upon themselves to mitigate damages? Because isn't that language in effect allowing the tenant to mitigate the damages?
It is allowing them to mitigate, but the question was, did Park have to allow them to?
I wouldn't go that far and say they have to.
Right, but that's the it's not expressly, it's still implied.
I'm hung up on that. I don't know, because I feel like it is what, again, it walks like a duck, it quacks like a duck. It's a duck. If they say, we're going to let you relet the premises, we're going to let you kind of present to us tenants, then it's an attempt for them, because why would they do that otherwise? It's an attempt for them to mitigate the damages. Why else would they let them or impose that duty and say, hey, you can do this without, what does that boil down to? It's a mitigation. They're saying, okay, you could present new tenants because you're leaving.
Okay. Catherine? Thank you, Tiffany.
Okay, so assuming there is an implied duty to mitigate, I think the issue is that advertisement was placed before the provision was signed. It had the word sublease in it. And was it a duty to mitigate, or was it a right by the tenants to find a tenant thereafter, which they didn't do?
So Kurzman is alleging that Park had a duty to mitigate, which, the language of stipulation 8 doesn't say that they have to accept any tenants that is presented. It's just they have the opportunity, is basically, to present them. I don't know. The way I looked at it is, it's like if I said to you guys all right now, I really like pizza, and then someone felt the need to go out and buy me a pizza, it's not like I'm saying I want to eat pizza right now. It's just saying I like pizza in general. So I'm not asking you to buy it for me. So I feel like in this case, you can present all the tenants you want, but we don't need to accept it. I don't know. That might be a little too far out there, but Kyle?
Then it goes back to the holding in Holy Properties, where the court held that just because a landlord has attempted to mitigate or has said it's okay, doesn't mean they're required to. The main issue is if there's a duty to mitigate. And from what we've all argued before, especially from the holding of that case, is that there's no duty. Even though they gave the option to mitigate, that doesn't make a duty arise.
I agree with you. And I like pizza. Jacqueline?
I really want pizza. I'm trying to, I can't seem to, I don't memorize case names. I'm horrible at it, and I'm sorry. But it's, where is it? For the love of God, I know it's on
Do you want to come back?
Yes, come back.
Okay,
I know it's
sure.
on the page.
Oh, it's okay. It's okay. Catherine, is your hand still up?
No, sorry, I'll lower it.
Oh, no, sorry. That was my bad. All right. We haven't heard from you in a while. I'm just going to call on some people to get some more conversation. So, Melissa, do you have any input here for this?
Well, I agree that there is no duty to mitigate in this case, and no right to sublease, because there is no sublease language in the document. And the language in the document is pretty clear to me, so.
So you're just going on the plain meaning?
Yeah. Yes.
Okay. Thank you. Rachel, what about you?
I think I'm with Melissa on this. It was pretty clear to me, there was no duty to mitigate, and just based on language, wasn't to sublease either.
Okay. Thanks, Rachel.
Mm-hmm.
Caitlin? Oh,
I don't think that there's a duty to mitigate because it's a commercial property. I don't think that a sublease was allowed because of paragraph 8. And as for if Park breached the stipulation when they took down the advertisement, I don't think they did because it said sublease.
Okay. Tiffany, your hand's up.
I'm on page 24 through 25 of Kurzman's brief, the reply brief. And I don't remember who mentioned holy properties. That's the case law that said there's no duty to mitigate. Under point B on page 24, it was found, or they're saying that holy properties does not apply because they're saying that, and they're also saying that the appeals court didn't even address it, but they're saying that the decision does not mention holy properties, but we observe that the landlord citation is inopposite because nothing in the doctrine prevents parties from agreeing between themselves as to obligations to release or mitigate. So holy properties is, to me, irrelevant here with regard to the duty to mitigate. In paragraph 8, I still think they expressly agreed between themselves to mitigate. Because they worded it a little funny doesn't mean that it's, it isn't what it is. It's a mitigation. They said, hey, you can relet the property. You can bring us, we don't have to accept them, but you can do it. And by them saying you can do it, you can have these people come and present their utility to us. They impose the duty on themselves to mitigate. So I'm still in the minority.
I think so. But thank you. Kyle?
But even removing the holy properties argument, it still doesn't expressly state in there that there is a duty to mitigate, because they're saying you can offer us a new tenant and we may accept it within our discretion. We don't have to. So it goes back to the argument that they're lawyers. If this is what they intended, it should have been stated. And since it's not expressly stated, it's really hard to imply something that the case law of New York is against.
Okay, so going back to my initial question, not the mitigating, just whether or not Park breached the stipulation by not allowing Kurzman to advertise. So just raise your hand if you think that Park did breach, just so we can find out. We'll go back to the mitigation at the end, don't worry. Or maybe my next question will. So just Tiffany thinks that they breached the contract, the stipulation.
Can we narrow it? Can you say what you just said again, please? I'm sorry.
If whether Park breached the stipulation by not allowing Kurzman to advertise.
I think they breached. They didn't breach for allowing them to advertise. They didn't breach because it said sublease. Sorry, I just got Invisalign today, so I'm like a little lispy. So I think it's because they didn't, because it said sublease is why they didn't breach, not because it was advertising.
Okay. Melissa, what you're commenting in the chat?
Yes, well, I might find a breach, maybe, because, I don't know, it is true that he should not put the word sublease in the advertisement, but maybe implicitly, even though the word advertisement is not in the document, I guess he had the right to advertise and said that he can show the property, maybe for, just, so that's why I think there might be a breach in there, because it says he could offer the property and the landlord was supposed to, in good faith, to approve.
So,
the tenant.
do you guys have an opinion on, according to the brief, there was only the one advertisement that was made and it used the word sublease, and then after Park said take it down, Kurzman never advertised again. It was just that one time, and once they took it down, they stopped. Jacqueline?
That was one of the things that like I kind of had an issue with. I mean, I understand that the advertising company was requested to take it down. Obviously, I'm not business minded, so I don't understand a lot of that stuff. But they were told to take it down and when they asked why, they were told the property's not ready yet. Now, the tenant, I'm assuming the advertising company would have called them and told them that the advertisement's being taken down, and it's because the property's not ready yet. The landlord stated that. So, in my mind, being a tenant, I would then think, okay, well then if the property's not ready yet and that's what the landlord's going to tell everybody, why should I put out more advertisements, or why should I try to get another tenant because the landlord just told this guy the property's not ready yet? And I don't wouldn't he have approached the landlord and asked like what is going on with the property that it's not ready yet?
Yeah.
I don't know. I'm just, it doesn't seem logical. Like, why wouldn't he have said, why isn't the property ready yet? I want to put an advertisement out for a tenant.
Right. John?
Yeah, I mean, I think it kind of just boils back down to subletting versus getting a brand new tenant. When you're advertising a sublease, it means, as we said previously, you're probably ready to move in right away. If you would have took that down and then maybe re-advertised saying new tenant available on a particular date, maybe not right away, but on a particular date, maybe that would have been one thing. But just the way it was done, like I said, I don't think there's any breach at all.
Thanks, John. Kyle?
I see another major issue, which I don't think anyone's touched yet. In order to enter into an agreement to lease property or to sublease, you have to have an interest in the property to do such. Park at the time of the advertisement did not have an interest in the property. The stipulation terminated his interest. So I can't even see, I actually see an issue with the enforceability of the contract itself, because the way I look at it is by the time the stipulation is entered into, you already agreed that damages would not be mitigated and you were liable for this. Even if they found a new person, I think there's a strong argument to argue that they should still be liable for the entire amount of the damages anyway. His interest ended when the stipulation was signed. He had no right to sublease, to assign, to find a new... He could found a new tenant to help out the landlord, but I don't think it would have helped mitigate the damages at all.
Thanks. Tiffany?
Okay, so I think the original agreement was severed. I think the obligations under the original agreement was severed, but they entered into a new agreement, and the new agreement is what is giving rise to the landlord's obligations under the new agreement. This provision 8 is really tripping me up, because I feel like provision 8, it's stating that we're letting you relet the premises. We're letting you, we're giving you the opportunity. In contracts, you have to act in good faith. And they're not acting, and they weren't acting in good faith. So why should we award them for not acting in good faith? They said, hey, you can relet the premises, no problem. The only thing that I find that Kurzman did wrong was put that it was a sublease. If he had put that, I don't know, the language for real estate when you want to relet property, then fine, put that language. Then that's what they should have put. And if they contacted the newspapers to take them down, he could have also contacted newspapers and told them to change that language.
But they didn't. So that's why
I'm saying that Kurzman didn't call to get the newspapers to turn it down, to take it down. The holding company called, the management company called the
right.
brokers and everything and told them to take it down. They could have easily said, you have to change this language.
Oh, instead of taking it down.
Exactly. And that would have been, to me, a better showing of good faith, that they acted in good faith in upholding paragraph 8.
I'm not sure how advertising goes, if it's easy or not to change wording. Yeah. So that is a good suggestion. Yusan?
I'd like to make sure if there was sublet agreement between two parties. I guess no. Then it's kind of hard to agree. Stipulation allows the tenant to locate suitable candidate for sublet. In addition, based on amended brief for respondents, page 20, even though Kurtzman asserted the plain meaning of this provision is tenant could continue to have commercial broker. He didn't say exactly kind of right to locate a suitable candidate for sublet. You know what I mean? So what I'm thinking is Kurtzman totally relied on the lower court's decision. That's my understanding.
Okay. Catherine? Thank you, Yusan.
Yeah, I was just looking back on the appellant's brief, page 11. I guess this is where Kyle was going, and I kind of agree that stipulation provided that the landlord reserved all rights under the original lease and expressly provided that Kurzman's vacatur of the premises was not to be considered a surrender of the lease. So he did have the landlord retained all of the rights under the original lease. And that provision 8, if it's ambiguous, I don't know if they should have granted summary judgment, but I really don't believe it created any sort of duty to mitigate.
Thanks, Catherine.
Yeah.
Jacqueline?
I have a question about, because I'm not really good at contract law. So I believe it has to be, right? The contract has to be upheld under good faith and fair dealing, right? But what is the difference between good faith and fair dealing and then being a really good business deal and try, like, because the way I'm seeing it is the real estate company, the landlord, is trying to be a business person. They're trying to get this tenant to either pay the fair market value for the apartment or the leasing area, or he tried to help him find something he could afford. And since that didn't work, to get him out and get somebody in that will pay fair market value. Now, obviously, I have some reserve as to how he went about doing that, but is that just good business practice, or is that being not good faith and fair dealing? Like, where is there a line for that?
Yeah, anyone have a good answer for Jacqueline? I don't know. I have Graves next too. He'd kill me.
Prestel is turning in his grave. I don't know. I don't understand. That's the thing. I don't know where there's a line. I mean, I see it both ways. That's my problem. I'm going both ways. I see the landlord being a jerk and trying to get a deal, but I also it's contracts law, and that's part of the deal. Your contract is up. I don't.
John?
I mean, with regards to that, I feel like there's a fine line between being devious and just acting in accordance with the law. There was no law breaking with this procedure. I mean, whether or not he's a good guy is kind of irrelevant. You don't have to be a good person, but going back to what I said just now, if he was acting in a devious manner, a misleading manner, that may be one thing, but that doesn't seem to be the case, in my opinion.
Okay. Yeah, that's what I kind of wanted to like separate out. You know, like, are we just looking at the landlord as like a big jerk, and that's why we want to find him guilty, or you know, and not get his damages, or are we separating that out and just look at the contract and was the contract legitimate?
Right.
Which I think it was. I don't have any arguments. I mean, I don't think summary judgment should be granted just because there are some questions as to who was contacted. I'm trying to find it, about somebody coming to view the property, to be a tenant, I guess, to re-tenant the property. He denied access, but then there's nothing in the record to prove it. So I feel like those are things that should be brought to trial and panned out, just to find out, like, was the landlord really blocking them from finding a new tenant, or is it just the advertisement? Because if it's just this advertisement and that's the only thing the tenant did, I don't see that there was a breach, because like we've said, there is no duty. Like, the landlord doesn't have a duty to go out of his way to mitigate his damages.
So you just brought up a good point, Jacqueline, that this basically is whether this issue is whether or not would lead to summary judgment.
Mm-hmm.
So I'll just ask that then. Kyle, I see your hand, but I'll get back to you in a second. What do you guys think that the third defense of that Kurzman's third affirmative defense, that they that Park breached the contract, should lead to a motion for summary judgment not being granted, or do you agree that with Park that it should have been granted? So raise your hand if you think that the motion for summary judgment should have been granted. In other words, Park didn't breach the contract. Okay, should have went the other way. All right, so I'll start. All right, so whose hands are not raised? Jacqueline, Tiffany.
Sorry.
No, it's okay. Oh, no, is it raised now? All right, so I will start with you, Tiffany, since it looks like your hand's the only one not raised. And then we'll go from there. All right, so Tiffany.
That Park did breach the contract? You want me to address?
So basically, should the motion for summary judgment have been granted? And by saying yes, you're saying that Park didn't breach the contract. And by saying no, you're saying that Park did breach the contract by not allowing Kurzman to, that they breached the stipulation in some way.
Okay, so I would go back to what I said previously about it being very narrow, and that if the Kurzman had used different language in the agreement, then we wouldn't be here. It wouldn't be an issue. If they had said relet and then Park did it, then they would breach. But I would come over to the majority if it was tailored to that, if that makes sense. It's very confusing to me too. So.
Okay. So you're on the fence? Is that what I'm getting here?
I would like it to be narrowed to the language of provision 8 of the advertisement also, with regard to their non-breach. If I was to find that they didn't breach, I would be narrowed to the language or the circumstances regarding the language in the advertisement.
So
because the advertisement said...
Okay, I understand. So based on that specific advertisement, they didn't breach.
Yes.
But in general, you think that they...
Exactly. So if the advertisement had said like relet or something, or just like a plain advertisement, then yes, they would have breached. Or if they acted in bad faith. So I would want the majority opinion to reflect that.
Okay, I got you.
Sorry.
It's okay.
Really difficult.
No, it's fine. Alyssa?
Okay, so I do not think that Park breached. However, now with what Tiffany just said, now I'm starting to think a little bit more about it because I do believe that issue in the ad kind of plays a big part in this. So I'm kind of on the fence a little bit right now. So that's where I'm standing with it.
Okay, we'll get back to you. Maybe some others will help persuade you. Jacqueline?
I guess like just reiterate my previous statement about summary judgment. It's just a question of the facts for me. The only thing is in this case, he's talking about summary judgment in regards to a full breach of the contract, and I don't know. I don't think because it's a question of such minute facts that I feel like maybe it should be granted, summary judgment should be granted just because the facts are so little. And I know I was just reading that the tenants were stating that they didn't have enough time to submit enough evidence, but they've already been through a complete discovery. What if you had evidence, you should have submitted it then? Why are you saying that you didn't have enough time? You're an attorney, you should have known. Like, that's just a little crazy. Like, why are you?
I'm sure they had to certify.
You have like what you? I mean, if you have new evidence, you should have. You should have petitioned the court to have it entered on the record, but you didn't. You're saying that you were what, blocked? Blocked how? Like what? How does that work? I didn't take that in law. I didn't learn that.
So you're on the fence is what I'm gathering here?
Yeah, I guess. I mean, I'm for summary judgment, or not summary judgment because there's question of fact, but if it can be argued that the facts that are questionable are so minute that it doesn't matter, then I will go the other way.
Okay. Thank you. Caitlin?
Sorry, I apologize for the dog. He doesn't like thunderstorms.
Oh, it's okay. I have it going on too.
But I would totally be fine with granting summary judgment. I don't think that they breached at all. And yeah, that's where I'm at.
Okay. Thank you. Yusan?
What I'm thinking is the landlord's motion to dismiss tenant's third affirmative defense should be granted should be granted as a matter of law based on the following kind of factors. First one is it's commercial property, and second one is because this property is commercial, so landlord has no duty to mitigate its duty. I mean, damage.
Right.
And depending on second factor, actually tenant has no right to advertise for sublet. That's my opinion.
Thank you, Yusan. Rachel?
I think Yusan just laid that out very nicely, and I agree.
Okay, thanks, Rachel. Melissa?
Yes. As I was saying before, and I kind of agree with what Jacqueline says, like there is no benefit, like no right sublease, but he could show the property. So it depends on the facts, like why he couldn't show the property. So I'm not sure if we should go with summary judgment or not.
So in this case, the fact is that there was an advertisement. It said sublease.
Yeah. The advertisement, I completely agree with that. It shouldn't say that.
And then there's nothing else to refute that there was an advertisement that said, relet or anything of that nature. So is this really, the question is whether or not this advertisement is a tribal issue of fact. I mean, that's how, at least how I'm looking at it. That's to everyone, not just to you, Melissa.
Yeah, no, the advertisement is completely wrong. Yeah, so there is no issue, in fact, regarding the advertisement. No.
All right, thanks, Melissa. I'll come back for your. I'll do another poll at the end. Kyle. Oh yeah, Kyle. You're muted, Kyle.
Oh, sorry. I said I think that summary judgment should be granted because I've already explained my reasoning 10 times, but mainly because the agreement didn't state that they had the right to advertise. So if that was in the agreement, now there'd be an issue of material fact, whether there was an advertisement, whether it was properly revoked. But since it doesn't state that, that's not really a major issue for the court to decide. It has no bearing on the enforceability or the breach of the contract.
Okay, thanks, Kyle. Who haven't I gotten to? John?
Yeah, I mean, as I said previously, I don't think there really is any sort of dispute with any sort of material fact. As Kyle just said, if it was outlined, if it was explicitly stated that you couldn't advertise, or if other things were put into the agreement, then it'd be one thing, but there wasn't. So I don't even really see there being any sort of issue.
Okay, cool. Thanks, John. Catherine?
I believe summary judgment should be granted. Even though provision 8 could be read as ambiguous, even assuming that there is an implied duty to mitigate, the fact that the word sublease is in the advertisement completely, I think, negates any option. If they had more evidence to support, if they had tried any other type of advertisement or any other type of relet, then I would say summary judgment should be dismissed, but I believe summary judgment should be granted here.
Kyle? Thank you, Catherine.
By everybody using the facts of what the agreement states, isn't everybody arguing that there is an issue, a material issue in dispute? Because if it wasn't for these facts, you wouldn't be deciding that way. That means it's now a tribal issue. Because it's what everyone is basing their opinion on. So now it's a factual determination on what these things mean. It's not as clear as everyone's making it out to see. That's why summary judges should be granted. At least that's the way I'm seeing everything right now.
Tiffany?
Kyle hit the nail on the head. I think there's some serious issues here, factual issues here. So that's why I'm not on the summary judgment side. I mean, I would come over if you guys, like I said, narrow the language, and I'm still dissenting on the first one, but I do think there's some serious issues here.
What do you think the serious issues are?
Factual issues regarding the landlord and tenant relationship, how they were, like the circumstances in which they left. Because it's my understanding is, and okay, so there's two things. Sorry, I'm going to like ranting. So there's two things. They could have been possibly forced out. They wanted to get out of the space, blah, blah, blah. But I forgot what I was going to say. They wanted to get out of the space. All right, you're going to have to come back to me. I'm sorry. I totally blanked on what I was going to say.
No problem. Catherine?
Okay, so going back to what Kyle said, I'm not sure if I'm contradicting myself, but I guess the case law that says once a lease is officially terminated, which it was upon the signing of that provision, that the tenant had no longer had a right in law to sublet. And the word sublet in the advertisement, it's not an issue of fact. So that's why we should grant summary judgment. Does that make sense, or is that still?
Kyle, is that what you? Okay. Yusan, your hands up.
Oh, actually, I have a question.
Okay.
Amended brief for respondents reads, even though
What page?
they're actually page number 27.
Thank you.
Ambiguity does not change the correctness of the lower court's decision based on tenant's reasonable expectation and reliance. My confusion is, even though their assertion is based on the plain language of paragraph 8 of the stipulation, they say it like this, and they supported their argument with Evans' case. I just wanted to make sure my interpretation is correct. So they said, if ambiguous, then this case cannot be cannot be construed as a matter of law. So I just wanted to know, this assertion is true, you know what I mean? If when there is kind of ambiguity in interpretation of stipulation, then we cannot construe that stipulation as a matter of law. Is it true?
Kyle, do you have the answer for her?
Yeah, I kind of thought of something. All right, so now I just forgot it though. Give me a minute. I'm sorry.
Okay. Tiffany?
So I remembered what I was thinking from before. So
Okay.
I wrote it down so I wouldn't forget this time. I think throughout the record, there are a lot of issues regarding like factual issues. Like there was a 20-something year relationship with these parties. Now it boils down to the good faith and how they dealt with each other, because the circumstances in which they left, it could be argued that they were either, they were trying to get out, in good faith, they couldn't renegotiate, blah, blah. I wouldn't say let's go as far as say forced out, but let's say from each other, they were trying to get out. But it goes back to now attorney competence, right? Because the attorneys should have known better. So in essence, maybe we should grant summary judgment on the grounds that it's an attorney competence issue, that if they wanted it in the contract, they should have been more clear, and they should have been better with including their conversations in writing, or putting their conversations in writing.
So you're switching sides?
Possibly.
You convince yourself. Kyle?
Okay, so I followed Tiffany's example and wrote it down so I didn't forget this time. But I'm starting to jump on Tiffany's side now. Because basically what we're doing is we're taking the terms of the agreement and we're saying, we're determining the intent of the parties in their ambiguous language. If we're trying to determine the intent of the parties, that is a factual-based determination, and we are not a fact-finding body, so we can't make a factual determination. And that's basically what we're doing. We're saying, okay, these ambiguous terms, they mean this. And that's not something we're allowed to do.
So I'm just going to jump in. if you look at the respondent's brief, on page 33, that's where their summary judgment article starts. So everybody take a minute and read through just skim it, just read through the first 3 pages of the summary judgment, because you guys are all saying, oh yeah, we should affirm the grant of summary judgment and just move on. There's no tribal issue. But the standard is really high, as you'll recall from civil procedure, to resolve something on summary judgment. And I think it's worth at least talking about those of you who believe that summary judgment is not an appropriate way to, because it's not about saying who's going to win. All you're doing by saying we're going to reverse the lower court is this should go forward for a trial on the merits. And so if there are arguments on each side, which your hour and 15 minutes discussion suggests that there may be, then maybe procedurally this isn't the right mechanism to do this. And so you've got to decide if summary judgment is the proper mechanism here, or if it should go to a jury. If those terms are ambiguous, is that a jury issue? If there are issues about the credibility of the witnesses or the credibility of the evidence, is that a jury issue? Or is it a matter of law? And so you've got to be confident that there are no issues of material fact and that there's nothing for a jury to decide. And the easiest way to answer that question is, is there any way to construe the facts where Kurtzman would win? Is there any way to construe the facts where Kurtzman would win? And if there is, then you've got a tribal issue of fact, because you're supposed to construe those facts in favor of the non-movement. Okay, so, and that's Kurtzman. So, and it's fine to decide, yeah, we don't think there really are any issues of material fact. We think everybody agrees on those facts, and that the facts as presented lead to a clear legal answer. If that's your decision, that's perfectly fine. But you guys are brushing off summary judgment pretty easily.
Okay. Jacqueline? Sorry, I was reading.
It's okay. So I'm looking at the summary judgment page, which is the respondent's brief, page 35, A, first paragraph. It says, it should not be granted where there summary judgment is a drastic remedy. It should not be granted where there is any doubt as to the existence of a triable issue of fact, or where the existence of such an issue is even arguable. So I'm trying to find exactly what their the fact is, because they're saying that they didn't, like I said, they didn't submit evidence to show that the landlord blocked them from showing the apartment. I think if they had tried to show the apartment, if they had attempted to have someone come and look at the premises and the landlord prevented them from doing so, I think that's an issue. However, where's the evidence? Like, why wasn't, like I said before, why wasn't the evidence submitted when they had discovery? Was there no evidence at the time? Are they trying to get evidence in now and they're just, there's no name submitted as to who? Couldn't they find the person that went to go view the apartment and get them on the stand? I mean, I don't know.
So on page 37, it seems like the bulk of their argument is that this advertisement.
Yeah.
And it just looks to me like, I mean, the advertisement was wrong. Like, sublease is not the same thing as what the stipulation says. So that's why I don't think that there's like a issue of fact. There's nothing else that says Kurzman tried to offer this apartment to anyone. They advertised.
Yeah, if you look at, Jacqueline, the brief answers your question, or at least provides an answer to your question about, okay, well, if there's no evidence, who do we construe that against? Do we construe it against Kurtzman for not bringing it forward, or against Park for not negating it somehow? And the brief at least suggests that the lack of evidence should go against the movement, not the non-movement. Because again, it's an extraordinary remedy, and it's not the non-movement's motion. The non-movement doesn't have to prove anything. The movement has to prove something.
But Professor, when you make an affirmative defense in a criminal case, the burden shifts, and you now have to, I mean, I know in criminal it's preponderance of the evidence if you make an affirmative defense. So like here, wouldn't it be the same that you're making the affirmative defense, so now you should have to be the one to show your to show a burden, like have a burden. That's how I would at least.
But the affirmative the affirmative defense was at the pleading stage, not the motion stage.
Right, but there was still no.
You can't file a motion and make me and shift the burden to me on your motion.
Well, what isn't the affirmative defense a response to the motion for summary judgment? No.
Affirmative defenses usually aren't alleged, and maybe I'm remembering this incorrectly, but affirmative defenses generally aren't alleged, and there's no mechanism to allege it in a motion for summary judgment. The only mechanism for alleging an affirmative defense is to do it in the answer.
Okay.
So, I mean, it would have already been there. Again, I'm not suggesting that summary judgment isn't appropriate. I just want to make sure that you guys really think about this and vet this.
John, did you have your hand up before?
Yeah, I mean, I was just going to say, on its face, I was agreeing with you. On its face, there is no issue of fact. Maybe what Professor was saying, summary judgment may not be appropriate. There might be another way to remedy the situation. Pretty much.
So has there been enough movement on summary judgment to change the outcome? So let's see, by show of your electronic hand, who still believes that summary judgment is an appropriate way to dispose of this?
I don't think I can raise my hand, but I do.
Okay. Okay.
I guess I'm the only one.
Who no longer believes that summary judgment is appropriate? Okay, so Catherine and Melissa, where do you guys come down? Oh, sorry, Catherine weighed in. Melissa? You're still mute.
I'm not sure.
Okay, fair enough. Fair enough. Okay. Okay, so Jeff, I'll tell you what, the most dramatic turnaround to me is Kyle.
Same.
Because Kyle just never moves. Like, Kyle's there, and he's dug in, and that's it.
I'm just surprised to see Kyle and Tiffany on the same side.
I know. It's like Scalia and Kagan.
I only have an issue because everybody's changing like they're deciding what they're doing this on by making a factual determination. They're stating we're interpreting this agreement to say that this is what it means. Now we're just created a factual issue. We can't decide that.
Yeah. Yeah, although I don't want anybody to underestimate a court's ability to find a way to do that. To just decide that's how we're going to do that. Okay, so Jeff, take about 5 minutes to wrap up and get your final, if you can get a final good majority, because it looks like you've got one.
Yeah.
See if you can get a final good majority. I would, if I were you as the chief, Jeff, I would make some people explain to me why they were for summary judgment. Now they're not for summary judgment, because you don't want it to be just, well, I heard one good argument that sounded good, so I went along with that. And then I heard another one that sounded good on the other side, and so I went along with that. And maybe if we had another 45 minutes, we could get everybody back on summary judgment again. I think you want to make sure that your court is a little more solid than that.
Okay. So Caitlin, you have switched. Why is that?
I switched because, where is it? Hold on, I'm just pulling it up. Because I think that it is, that it was an issue of fact, and that that we are basically going back and forth with, paragraph 8 says this, then, this is what happened. So I think that maybe there's another remedy that's more appropriate.
Okay. Thank you. Jacqueline, you were on the fence and now you're not.
Yeah, like I said, I wasn't sure how minute the issues were. If they were minute issues that we had with the facts, and it was just, why didn't he submit evidence, which doesn't make sense, like he would have already submitted it. So, but the fact that we're having issues and difficulties with the facts as to how they would be interpreted, that I can't agree with being under summary judgment, because we're saying that, like, one of the things that I specifically have an issue with is they posted this thing that said sublease instead of tenant, but instead of just approaching them and saying you used the wrong terms, they stated that a property wasn't ready. Did the tenant know that? Did the tenant not know? Why didn't the tenant? It's just too many questions that could go the other way. And
okay, so we all initially, back in the very beginning, agreed that the stipulation didn't confer a right to sublease to new tenants. So Grossman wasn't even allowed to sublease. So, which is why I think that this whole, there's no issue here. They weren't allowed to sublease. We all agreed to that. So now their affirmative defense is saying that they breached the contract, but they wrote the word sublease. They weren't allowed to. We agreed to that. So why are we?
Because they were allowed to find.
Not just to you. Right, they were, but they didn't. They wrote sublease, and that's it. And then they never tried again, and that was it.
Well, I'm thinking that. Well, how I'm interpreting it is maybe they got a call from the advertising company that said you can't advertise because the property's not ready yet. And then why would I, as a tenant, continue to advertise to find a new tenant if the landlord stated that the property is or untenable or whatever? So I don't see, like, it then wouldn't be reasonable for the tenant to go out and continue to spend money on advertising and exert effort to find a new tenant if he thought in his head that the landlord was not going to let him find a tenant for the house because he told the advertising company that the property wasn't going to have a tenant. So no matter what I do as a tenant, you're not going to let somebody come in there because you're going to tell them that the property's not ready. It's not a matter of the fact that I used the wrong word. If that would have been the fact, if that would have been what was said, then yes, I would agree. Because now, why wouldn't the tenant go out and find someone? Obviously, then a reasonable person would change the advertisement or find someone else. I don't know.
Okay, we'll keep going because I can.
Yep.
Catherine?
Yeah, I was really with you for majority of it. But then I guess because Professor reminded us that the burden really is on the moving party, and because it hadn't switched back yet to the non-moving party, they might not have had a chance to show more evidence as to what else they did to try to relet besides that one advertisement. That could be an issue of fact. And I do agree that, you know, the word sublet in that advertisement clearly goes against the case law, but the duty to mitigate may be ambiguous. Did he have a duty to at least alert the tenant, hey, you know, I removed this advertisement, but here's your opportunity, put another one up there? I don't know. Maybe that's the issue of fact that I'm struggling with.
Okay, and we'll end with Kyle before we take a vote.
I switched sides again. I'm back to my original reasoning because I think I just got lost in everyone's arguments. I'm just just in the reading of the contract does not appear to be ambiguous. It's that they had the ability to offer new tenants. They were not required to. The landlord was not required to take the person. They were not really required to do any permissive action. So I'm saying that there is no material issue of fact. Again.
All right. Thank you, Kyle. All right, so let's just take one last vote here. Raise your hand if you believe that there should not be a motion for summary judgment granted, meaning there is an triable issue of fact here.
There is or there isn't?
Is. There is.
Yeah, and let me make a friendly amendment to the way you stated that.
Oh.
I think Jeff's asking you to indicate whether you would
not grant summary judgment.
Right. So whether you would reverse the lower court's decision, right?
Yes.
Yeah. So whether you would reverse the lower court's decision. You guys don't have the ability to grant or not grant summary judgment. That's already been done. You only have the ability to affirm or reverse what's been done and order instructions consistent with. So you can reverse and remand for a trial on damages. You can reverse and render the damages, or you can
affirm.
No, sorry. Yeah, so you can reverse and render, you can reverse and remand, or you can affirm. Or affirm and remand. Yeah. Yeah, that's right. You can affirm. So who wants to, the lower court decision, hold on, I'm confused now. So let's go with the trial court decision. Who wants to affirm the trial court's grant of summary judgment?
Yes.
And Jeff, you're in that too.
Yeah.
Wait, Kyle, aren't you there?
Yeah, Kyle is.
Okay, so lower your hands. And then who wants to reverse? Which means that you would go back for a trial on the merits. Okay. Okay, so we've still got a majority. We don't have a super strong majority, but we've still got a majority. So the majority of you want to reverse the trial court decision and order the court to set a trial on the merits consistent with, and proceed consistent with your decision. So you'll have to address the summary judgment standard. The fact that you don't believe that Park overcame the summary judgment standard, and then you're going to give some guidance to the lower court on how you believe the issue, that those issues perhaps ought to be resolved. If you are dissenting, so there's a reverse and remand. There's an affirm, which means which means that you agree with the trial court's grant of summary judgment. So there's reverse and remand. There's affirm and render on the damages, or there's affirm and remand for a hearing on damages. Okay, so your options are reverse, affirm and remand, affirm and render. That's if you're writing the majority. If you're writing the dissent, you can do whatever you want. So Jeff, you want to tell them what they did?
You mean like what's the actual opinion decision? Yeah, you guys are wrong. The Court of Appeals just decided this on June 23rd of this year, and it says the order of the appellate division should be modified without cost by granting plaintiff's motion for summary judgment, dismissing defendant's third affirmative defense, and as so modified, affirmed and certified question answered in the negative. Plaintiff met its initial burden of demonstrating its entitlement to summary judgment, dismissing defendant's third affirmative defense, alleging that plaintiff breached the stipulation between the parties. They give some cites. Defendant's submission in opposition to plaintiff's motion failed to raise a material tribal issue of fact. And then they repeat themselves again, saying order modified without cost by granting plaintiff's motion for summary judgment, dismissing the third affirmative defense, and so, as so modified, affirmed and certified question answered in the negative in a memorandum. And that was, yeah, so they granted the, or affirmed the motion for summary judgment.
For what it's worth, I disagree. I agree with the appellate division.
But Chief Justice took no part in that decision.
There you go.
But the rest of them agreed. So
if you draft a dissent, you've got to explain why you think the majority was wrong, and that's going to focus primarily on the summary judgment standard. Let's see. Anything else before we break? Okay. So I have got your revised opinions that I'm looking at over the weekend, and I'll get those back to you, I hope before Monday, but surely by Monday. And then we will meet Tuesday for our last deliberation, and then Thursday will be a debriefing where I'll have a series of questions that we'll go through sort of about the experience of serving as the court. Okay, have a fantastic weekend. Good job, Chief.
Thanks. Bye-bye.